OK 啊，大佬，即係個大佬當年福主導包尾嗰個，自動波係咯，哇！都揸到10幾都冇嘢好話，唔係佢好即係幾條快差唔多啊！我有個零
多次聲，試多次聲。1、2、3 testing， 1、2、3 testing， 1、2、3。1、2、3 testing， 1、2、3、4， 1、2、3、4 testing， 1、2、3、4， 1、2、3、4， 1、2、3、4 testing， 可唔 OK？ 1、2、3、4 testing， 1、2、3、4 testing， 1、2、3、4，可唔 OK？ 1、2、3、4 testing， OK。1、2、3、4 testing， 1、2、3。1、2、3 testing， 1、2、3 testing， 1、2、3 testing， 1、2、3 testing， 1、2、3 testing， 1、2、3 testing， 1、2、3 testing， 1、2、3。
各位朋友，各位傳媒朋友。
我開始先，CJ。
Oh right
自己上先。歡迎大家出席。咁麻煩場內咧，今日就大家全程戴口罩同埋保持適當嘅社交距離。終審法院首席法官馬道立咧，一陣間會先同我哋講幾句嘅，咁再回答大家嘅提問。唔該晒 CJ。
各位朋友，傳媒朋友，早晨。估唔到係10年過得咁快啊！10年前咁，我係第一次見到你哋，都係第一個 press con。咁而家係最後一次作為 CJ 見大家㗎啦嚇。首先咧，我想係多謝大家嚇，俾我俾司法機構你哋嘅支持。就算有時你哋可能批評司法機構都好啦嚇，我覺得呢個係應該嘅。咁啊，我都係好多謝你哋嘅支持。今日咧特別多謝你可以嚟到會展咁遠聽呢個記者會㗎啦嚇，疫情嘅問題㗎啦。我仲有幾日，咁我就離任我嘅有一個職位啦嚇。星期5係我嘅最後一個日子㗎啦。我知道大家可能有好多問題，有啲問題咧可能唔係好適宜會答㗎啦。不過即係I'll do my best 嚇，就係我答你哋。有好啲嘢我係想講嘅，不過咧我諗你可以等到聽日，因為聽日我最後嘅 sitting 㗎啦，咁我都會講啲嘢㗎啦。聽日下晝5點鐘。今日咧，我想講啲好短，即係我已經俾啲機會你哋問啲問題啦。我想講我啲即係首席法官嘅使命，同埋我啲將來嘅期望。10年前咧，我唔記得邊個問我啦，即係你嘅使命係乜嘢？司法機構嘅使命，你作為首席法官嘅使命係乜嘢？剛才係我講得好簡單，使命係咩咧？就係維持香港嘅法治。而家嘅使命咧係一樣嘅。將來咧，我諗你下個星期你都可以問張官。我諗佢呢啲都係佢嘅使命㗎啦。維持香港嘅法治咧，我哋係需要一個獨立嘅司法機構。即係獨立嘅司法機構咧，係香港嘅基本法係規定嘅。呢個係我已經講咗好多次㗎啦。你需要一個獨立嘅司法機構，先至可以保障個人嘅權利同埋自由。今日我想好簡單解釋，對大家去了解咧，其實司法獨立嘅意思係咩嚟嘅？有幾點嘅。處理啲案件咧，香港啲法官咧，淨係需要睇法律嘅理據嘅，即係你係依法處理啲案件，同埋咧係都需要我哋叫法律嘅精神。 公平公正處理啲案件，呢個係最基本㗎啦。你唔會受得俾任何人影響，任何人嘅意見，任何人特別，任何人嘅政治嘅意見影響。同埋大家都要記得咧，最重要咧，講咗好多次啦嚇，人人係法律面前係平等嘅，冇人可以凌駕上法律嗰度。同埋根據法律嘅意思咧，最基本咧都係要根據香港嘅基本法。同埋咧，大家都要記得咧，每位法官咧都要宣誓嘅，有個司法嘅誓言啊。司法誓言咧，咁要擁護香港嘅基本法，效忠香港特區，無居無偏無私無欺之精神，維護法制，處理啲案件。所以呢個咧就包括係可以話嘅使命 ，CJ 嘅使命。有好多評論者咧，就係話香港變咗好多噶咯，比以前變咗好多。呢個可能係，但係咧社會變咗幾多都好。但我想知道咧，就係大家知道咧，大家了解咧，就係司法機構同埋我哋嘅態度咧，會不變嘅。所以呢個係個維持香港嘅法治嗰個意思。好簡單嚟講，我啲期望係乜嘢咧？香港嘅法治咧係香港社會嘅基石，大家係需要咪尊重法官嚇？你尊重我又好，唔尊重我又好，但係我就覺得希望咧，市民咧就會尊重我哋嘅司法嘅制度同埋嘅法治。我相信咧，社會整體上咧係尊重香港嘅法治嘅。講咗好多次咧，就係任何人都可以評論我哋嘅工作，任何人都可以批評我哋嘅工作。嗱，呢排好多人都你可以話批評我哋嘅工作啦嚇，批評啲判決啦，呢個好嘅。我覺得呢個係好健全。但係咧，如果你係想批評咧，一定係要有理據嘅，一定有理由先至批評。同埋最近都聽到好多人話係咪司法機構需要改革咧嚇？呢個係我諗最近呢幾個月都係。你都睇到好多評論者係咁樣講，呢幾日可能都係好多人都咁樣講。我哋嘅司法機構嘅立場咧，唔係話係反對嘅，因為如果有咩地方我哋可以改善嘅咧，我哋一定會跟進嘅。呢個都係好多年係我哋嘅立場，我哋係講過。但係咧，如果你講改革咧，你要俾啲細節同埋啲理由。同埋啲理據點解，同埋喺邊度需要改革？咁如果有啲細節咧，咁我哋一定會可以研究。但係咧，如果人哋就話我唔中意你今日嘅判決、琴日嘅判決，或者明天嘅判決，所以你要改革咧？呢個唔係一個特別好嘅理由，我覺得好多市民咧就會覺得好難接受。如果你嘅意思就話我想次我想打官司嗰陣時候一定要贏，如果贏唔到咧，先至要改革咧，但係呢個唔係一個即係特別係好嘅理由㗎啦。 所以我最大嘅希望係咩嘢咧？就係香港會繼續係一個社會，係一個法治嘅社會。好啦，呢度我就想講講咁多㗎啦。咁啊而家你都知道，咁我要講英文㗎啦嚇，都講翻我剛才講嗰啲説話。So I'm going to sort of just say in English what I've just said to everybody. So I want to welcome everybody here and thank you for coming to the Convention Center for reasons of health. We're nicely spaced out, at least some of us are nicely spaced out. And thank you for coming. And I wish to thank all of you for the support you have shown the judiciary and myself through the years. Even when you have criticized us, this is healthy, that there should be comments on the work of the courts. Courts are not above criticism. And I thank you for the interest that all of you have shown in the workings of the judiciary. I shall be retiring in a few days' time. My last day is Friday, although my very last day, I suppose you can say, is Sunday. So today is the last time I will have the pleasure of addressing your questions as Chief Justice. 10 years have gone by very quickly. You'll have many questions for me, and I'll do it. But you will know from some of my replies that sometimes it's not appropriate to reply to certain questions, particularly about cases which are pending. But what I do want to sort of briefly talk about are two topics. I'll speak more tomorrow because my farewell sitting is at 5 o'clock, and I shall be saying something then as well. But I do want to say something today about the Chief Justice's mission, or the judiciary's mission, because this is what I talked about 10 years ago, and also perhaps briefly about what my hopes are for the future. Now, 10 years ago, when I first fielded questions from all of you, I was asked whether I had a mission, and I replied, my mission is the same as the judiciary's mission, and it's a simple one, and it's to uphold the rule of law. This remains my mission today, and you can ask my successor, Justice Andrew Cheung, when you see him on Monday, I think, and I hope he will say the same to you. The maintenance of the rule of law requires an independent judiciary. The concept of an independent judiciary is required, not just protected by, it's required under the basic law. You're familiar now with the articles. I've given them to you often enough. Articles 2, 19, and 85. You can look it up for yourselves and you can see the concept of the independence of judiciary referred to and required under the basic law. An independent judiciary ensures, among other things, the protection of rights and freedoms, which are also set out in the basic law. Now, I want to again talk briefly about what the independence of the judiciary means. It's not a political statement. It's not a political concept. What it means, in essence, is that in the handling of cases, judges are going to look only at the law, legal principle in the spirit of the law, looking to decide cases according to the legal merits. And at its most basic, and never lose sight of this, is to decide cases fairly and justly, and not to be influenced by any beliefs, anything, particularly political beliefs, but to be influenced only by the law. And central to this is the concept of equality before the law. Everybody is equal before the law. Nobody is more equal than anybody else. all judges take the judicial oath, and this guides a judge as to what he or she should be doing. And that requires upholding the basic law, bearing allegiance to Hong Kong, to Hong Kong's SAR, and to decide cases fearlessly without fear or favor and handle these cases. Many people have said that Hong Kong has changed a lot recently compared with before. Whether that is so or not, I'd like to think that the judiciary remains stable and consistent in upholding the rule of law and abiding by those principles, and judges abiding by their judicial oath, as I've mentioned. Our system of law hopefully provides the sort of stability which society often, certainly sometimes, needs. My hopes for the future center around, again, the rule of law. It's been said it's been called the cornerstone of our community. Indeed it is, and it should be respected. I hope the public will continue to have confidence in the rule of law in our legal system. I believe most people, most of our community, do respect and support the rule of law. I've said many times, and I've said at the beginning, that it's good to comment on the work of the courts, even in a negative way, even to criticize the courts. At the very least, it shows an interest in the work of the courts, an interest in something which is important. But in order not to lose the respect and confidence of the people whom the law serves, it's important that any criticisms made, however strong, have a basis to them, and that they are not made just because you're not happy with a particular result. And sometimes we have a lot of cases which have political origins, and those are the type of cases I'm specifically referring to. As far as the judiciary is concerned, there's a lot of talk also recently about reforms, whether there's a need for reform. Some people say there's a need for reform, others do so in perhaps strong terms. Our position, when I say our position, I'm referring to the judiciary's position, has all along been the same. If there's any room for improvement, we will pursue it, we will consider it. If there is any reform that is required, give us the details and we will consider it. But it's not particularly satisfactory if there's a call for reform simply on the basis of a result that one doesn't like. One's got to do a little more than that in order to make good a case for reform. It is certainly not a good starting point or acceptable to say, I want reforms to ensure that I will always get the result which I want. So my hope for the future is the maintenance of Hong Kong's rule of law, and that Hong Kong remains a society which is governed by the rule of law. So that's all I wish to say, and I'll be happy now to do the best I can and answer your questions. Thank you.
好，而家係提問嘅環節，咁請先介紹咗你哋代表嘅機構，咁然之後用咪發問，咁每人可以問3條問題，或者 RTHK 先。
CJ 你好，我香港電台嘅有3個問題。第一個問題就係關於法治。其實你上任之初已經承諾，你任內最大嘅使命就係維護法治。你頭先都有講到。咁你覺得你喺呢方面又做成點？你俾自己幾多分呢？咁過去10年其實好多人話香港法治係受損，甚至有人話法治已死。包括你任內都有2次釋法，其中一次都係受爭議嘅基本法104條。咁你點睇呢啲嘅評論呢？ 第二就係關於國安法嘅，其實即係都有好多評論就話國安法嘅實施亦都係削弱咗香港嘅司法獨立啦。一條全國性嘅法律由人大去頒布，亦都引入咗一啲內地嘅執法機關、國安委，而法官嘅即係國安法嘅法官嘅任命，亦都唔係全權由即係司法機構可以去做推薦。你認唔認同其實國安法亦都係會削弱咗香港嘅司法獨立同埋法治呢？第三條問題係關於三權分立嘅。過去你都冇一啲即係明確嘅立場啦，即係喺一個即係三權分立嘅爭議，今年都有講到嘅時候。但係咧，其實睇翻你2014年喺法律年度開啓嚟，你都有提到其實基本法係清楚定明立法、行政、司法機關係三權分立嘅原則，並以頗為明確嘅字眼去界定三者不同角色。你而家仲認唔認同香港係有三權分立嘅咧？定係你呢個立場已經改變咗？唔該。
好多謝。第一個問題咧，我諗我唔會俾自己幾多分㗎。我諗你俾我分係好㗎啦，同埋香港嘅市民俾我分。因為我自己你問我做得好定做得唔好咧，我係希望我係做得好嚇。咁多年嘅使命咧，咁我哋係希望我係維持咗香港嘅法治㗎啦。呢個好多人話係香港仲有冇法治嘅咧？我相信香港有法治。點解有法治？點解咁樣講嘅咧？因為我知道係我哋嘅法官嘅同埋嘅法院嘅態度係乜嘢，同埋我哋都係根據基本法係做即係依法處理咧嘅意思係根據基本法，根據嘅剛才我講嘅司法嘅誓言。第二個問題講國安法咧，處理國安法咧係同其他啲我諗法律就係啲法律嘅問題係一樣嘅，一定有挑戰嘅嚇。但係咧，我哋嘅法院嘅態度，我哋嘅 approach 咧都係一樣嘅。第一，根據香港基本法。法官根據佢哋嘅司法嘅誓言，咁你睇即係邊個贏、邊個輸、邊個有罪、邊個冇罪嚇，你都係睇法律嘅理據。從頭到尾咧，都係一個法律嘅問題，唔係一個政治嘅問題。因為大家都知道咧，呢個又講咗好多次嘅咧。我哋嘅法庭咧唔會處理、唔會決定啲政治嘅問題，淨係處理決定啲法律嘅問題。第三個問題咧，你就講三權分立啦。但係呢度係好多年前我都係講過嘅，係個 Opening of Legal Year 我哋嘅法律開啟典禮咧，都係我哋係講過嘅。但係咧，對我嚟講咧，呢個唔係一個政治嘅問題嚟嘅嚇，呢個我要強調啊。我嘅意思咧。三權即係我哋冇用呢個唱法三權分立，而家呢個變咗一個好政治一個好爭議性嘅問題嘅咧。但係最需要記得係咩咧？係香港有司法獨立，所以我有成日都係講咩咧？就係大家要睇下香港基本法有3條係強調規定。香港係有司法獨立嘅，所以呢個係我諗最需要記得就係呢點。我係唔係講政治嗰啲問題，我係講完全係講法律嗰啲問題。喺呢度咧係冇變過。
好，下一個總。
Thank you, Mr. Ma. Alvin from Citizen News. This press conference and your earlier 13-page statement, in my recollection, is kind of a rare for the judiciary, especially in this political climate. Do you feel the courts and judges, aside from speaking through judgment, now comes to a need to defend themselves when the Secretary for Justice does not always readily available for help to perhaps clear the air and respond to some of the attacks? My second question is, you previously made it, you today again made it very clear that the cases related to national securities are treated like all the other cases, criminal or civil. But the national security law provides very clear that it shall prevails over local laws, and constitutionally it's almost the same as the basic law. Do you still feel that after the CFA hear the first NSL case, that all cases are treated alike? And what is exactly your source of confidence towards that? And is common law the answer to that? And my final question is, throughout your time in the CFA, there is some ruling on diversity, but it seems fair to say that constitutional review is now a no-go zone for some of the constitutional lawyers. Do you feel the court is sort of restrained and the hands are tied and could only achieve some incremental justice in that sense and could not enter into an area and now being very controversial, but it's important because it's the constitutional reviews. Has this becomes the case? Thank you.
Well, this conference is, this press conference is nothing new, because I think I'm going to say all outgoing Chief Justices would like to meet the press for a final time, so this is not different, but I understand your point. You are asking me, this year I've issued a lot of statements, and I haven't counted how many statements I've issued this year, but probably more than any other year during my 10 years. I think I accept that. The judiciary does not issue statements very often. I don't issue statements often, but there is a need to when there is misunderstanding in the community about the work of the courts and something needs to be said. Now, I emphasize that the last thing, not the last thing, we don't enter into any political debate at all. This is, as far as we are concerned, as far as I'm concerned, not relevant to our work. But what is relevant to our work, if there's been any misunderstanding on the part of the public, the community, about what courts do and how courts do it. Now, I issued a very long statement in, I think, September. It's about 18 pages, which I think is probably unprecedented, certainly for me, and for the Hong Kong judiciary. And there was a need to inform the public briefly, even though it's 18 pages, about how the law works. Now, the issuing of a statement is for that purpose alone. There are many people who have responsibilities towards the rule of law. They know who they are. The government knows. Everybody who has a stake in the rule of law has a responsibility towards it. And I'm discharging my responsibility on behalf of the judiciary when I issue these statements. It's not any sort of political game that we play, nor is it any sort of criticism of anybody else. It's simply a need for the public to have answers to those questions which the public would be asking. Now, the second question, Alvin, is national security law. Now, it's not right for me to go into a legal debate about the laws, about how the national security law works. Apart from anything else, there's a case pending which will be heard by the Court of Final Appeal on February the 1st without me, because I will then be retired, dealing with issues which arise. But I just perhaps like to mention one thing, is that the national security law does contain specific references to the need to abide by the basic law, and also the need to look and pay regard to fundamental rights. And you will see in the national security law, for example, reference to the freedom of the press, the freedom of association, and other rights which are protected under our basic law and in the Bill of Rights. So all these questions which these legal questions may at times pull in different directions, may have to be resolved by the courts at some stage. So that's why I say the approach of the courts dealing with national security law matters is the same approach as with any other law. That's not to say that there are no challenges. Of course there will be. Third question relates to constitutional review, judicial review. Well, the courts have to deal with issues which arise. Some are easier to deal with than others. Others are complicated. I've just mentioned that certainly rights can pull in different directions. You can see that by recent decisions of the courts dealing with discrimination, dealing with same-sex issues, dealing with constitutional issues. Matters pull in different directions, and it is the court that ultimately has the duty to try to balance interests or to resolve these matters, because if the courts don't resolve them, nobody else can resolve these legal matters. Yes, thank you, Alvin.
TVB 你好啊，無線嘅3條問題。第一條問題就想問下咧，你卸任咗之後咧，會唔會都有意擔任非常任法官咧？即係退休後有冇啲咩計劃啊？心情點樣？第二樣嘢就係頭先你都提到司法改革啦。咁其實你自己個人認為，其實香港係咪需要司法改革咧？因為頭先你話都要公平公正去處理案件，咁但係都有意見就話有啲法官有外國嘅國籍或者物業，都會擔心被外國制裁而唔能夠作出一個公平嘅裁決。咁你點睇咧？咁最後一條問題就曾經有報道就話你有提名太太去做過非常任法官，咁就即係有啲建制派人士就對呢個做法有啲詬病啦。咁你點睇咧？會唔會覺得即係係咯？呢一樣嘢係唔該。
我答最後嗰個問題先啦。呢個係呢個係可以話係唔關我嘅事嘅。呢個一路我都係或者唔係，我又應該唔評論啦嚇。但係呢個係同我係冇關係㗎啦。第一個問題咧就係退休之後做咩嘢咧？呢個係一個好嘅問題。我自己都唔係好知，因為係呢個禮拜、呢個月、呢幾個月都好忙，所以我諗等下個月我先至好啲坐喺度，會諗清楚會做乜嘢㗎啦嚇。做唔做非常任法官咧，即係 NPJ 咧？我就唔會。改革嗰度咧，你就問我有冇地方需要改革嗱？我嘅立場咧都剛才講咗㗎啦。如果有地方我哋可以需要係改善嘅咧，我哋一定會跟進嘅。即係差唔多而家20年前咧，我哋係開始我哋叫嘅 CJR Civil Justice Reform 個民事司法制度改革咧，係咁我哋係呢度係研究咗、考慮咗差唔多10年，咁就係落實嘅改革㗎啦嚇。如果仲需要啲咩改革嘅咧，咁我哋係一路我哋都會係聽人哋點樣講嘅咧。如果有人可以俾啲細節我哋，咁我哋一定會去一定會研究㗎嚇。但係如果你問我，需唔需要改革嘅法官嘅態度係咪公平公正審啲案件？人人都係喺法律面前係平等嘅，呢啲好基本嘅原則嘅咧，呢啲係當然係唔可以改嘅啦。因為呢啲係好基本嘅原則。
司姐你好，有線電視。有3條問題啦。第一個問題都係想問翻你頭先提到使命嗰樣嘢啦。你提到過去10年你都好努力去維護香港法治啦。其實呢10年嚟嘅工作咧係比你即係想像中 艱巨定係容易嘅咧？你10年嚟有冇面對過任何外在或者內在嘅壓力咧？第二樣嘢就係個司法改革。頭先你都提到，其實係司法機構或者你本人係唔反對啦。有其中一個講法就係即係前中院法官列顯倫都有提過，佢覺得即係香港係有需要行司法改革，係因為而家咧佢睇到本地法院可能有陣時去引用一啲外國嘅原則或者理論嘅時候咧，可能已經係唔係咁適用於本地嘅一啲案件。你自己認唔認同呢個可能都係香港需要行司法改革嘅理由咧？第三樣嘢都係想追問翻嗰個三權分立，即係頭先你都答過一次㗎啦。咁但係你頭先就提到話其實呢幾個字都比較敏感。不如我哋唔好用呢個字，我哋最緊要就係知道香港係有一個獨立嘅即係司法嘅制度啦。但係我諗三權分立呢個概念咧，其實喺香港嚟講都真係根深蒂固。大家都好想知道究竟我哋點樣去理解呢件事咧？當即係政府官員有提過回歸前後其實香港係冇行三權分立嘅時候，究竟係我哋過往係理解錯咗啊，定還是好似你咁講，香港真係有啲嘢變咗，我哋唔知咧？係啦，咁另外仲有一條啫，就係頭先即係司法已死。頭先都講過，好多人而家成日提到司法已死呢樣嘢。其實你作為一個法治嘅捍衛者，你睇到香港人而家對香港嘅司法制度已經失去信心，甚至想離開香港嘅時候，你個人有咩感受咧？你會點樣去游說香港人係要仍然對香港嘅法治同埋司法制度有信心咧？唔該。
我諗到第一個同埋第4個問題咧係差唔多啦嚇，我當係要1A 1B 啦嚇，因為即係你問我係呢10年係有冇壓力，係咪好容易做或者好難做咧？呢個好難答你嘅。日日咧，我10年前咧，我係面對好多挑戰嘅。今日面對嘅挑戰咧都有。係一樣，唔係一樣，都係有一樣咁多。但係嗰啲挑戰係變咗啦嚇，一定會啦。10年過咗㗎啦，所以你話容易唔容易，其實呢個係都要做㗎啦嚇。有冇壓力咧？日日都有壓力嘅，呢個係工作嘅壓力。如果你問我有冇人或者任何人機構俾壓力我咧，咁就完全係冇嘅，因為我知道。我係需要做乜嘢？我法官都係，佢哋都知道佢哋嘅責任係乜嘢，履行佢哋嘅職責。佢哋要我講咗啦，根據佢哋嘅司法嘅誓言，根據嘅香港嘅基本法，呢個係佢哋最大嘅壓力。即係你係處理案件要依法，依法咧一啲都唔簡單嘅有時。所以呢個係講呢度嘅壓力㗎啦，同埋咧。咁咧，依個咧就係去咗你嘅第2個問題嗰度啦，改革同埋你就係提咗列顯倫先生講咗乜嘢啦嚇。法律咧係有時係好複雜嘅嚇。我諗大家都依個好多人都唔會話係反對呢句説話噶啦，亦唔同意呢句説話。有時係好複雜嘅。如果複雜咧，你都要。有時咧就係比較有好多考慮嘅，即係有好多啲因素嚇。所以如果唔複雜嘅咧，你都要諗下啊。第度嗰啲即係我哋嘅普通法咧有個我哋叫 doctrine of precedent。咁我哋都話睇下英國嗰啲法庭點樣判咧，或者澳洲咧嚇。或者制度，所以你都要係呢個係好普通嘅，呢個係應該做嘅嚇。我相信係我哋大家即係讀過書、讀過法律咧，大家都知道係呢度係應該咁樣做嘅。列顯倫先生其他嗰啲嘢咧，我就唔評論啦，我都唔應該評論，唔應該評論太多噶啦。三權分立嗰度咧，一路咧。我哋嘅立場啊，即係我嘅了解咧不變咗，因為我哋一路我嘅了解咧就係對我嚟講，我淨係睇法律嘅方面嗰度，就我就剛才講咗，睇我哋嘅基本法好清楚係寫住係有 香港係有司法獨立。呢3條我再講一次，第2、第19、第85。但係如果你係問我政治嗰度方面係咪變咗咧？呢度我就唔敢講噶啦。其實我都唔應該講，我淨係講我哋嘅法律嗰個立場。咩啊？點解？點解？咁就係應該嘅。即係如果你話好過你唔信法治嘅啦嚇，法治咧就係一個 stabilizing factor 嚟嘅可以咁樣講嚇。所以你要信，因為人咧就係有權利有自由。邊個係要 enforce 呢啲權利同埋自由咧？就係你要靠住啲法院嘅啦，法庭。
Hi, good afternoon, Mr. Ma. Just Chris from the South China Morning Post. So you in your opening speech, you were saying that one of your aspirations is, things go to judicial and then the judiciary will goes on to have its independence. But we've seen after following the implementation of the national security law, it seems some of the aspect did change. Things like, the designation of judges by the chief executive, and until now, we have not seen the list of the designated judges who have been appointed. So do you think your aspiration and your hope for the future for judiciary was a little bit too rosy? And why, until now, we have not seen the list of the designated judges? And has the chief executive ever consulted you before she designated any judges? The second question is that I think the non-permanent CFA judge, Justice Bukhari, I think one of his arguments has been that Hong Kong probably Hong Kong enjoyed the judicial independence, probably not so much so as judicial autonomy, which is subjected to the power of interpretation by the NPCSD. Given the national security law, which has the power now to send Hong Kongers to mainland for trial and then also surveillance Hong Kongers in certain cases without the court's approval, then how can Hong Kong people still have confidence in the judiciary that it will still safeguard their rights, given that some of the matters seem to have already gone out of the court's hand and what is governed by the basic law? My last question is, some members and the public have been increasingly critical of the judges' decision, be they activists and government supporters. We're also seeing an increasing trend of pro-Beijing media, even mainland officials targeting the judiciary, asking for reforms. Under such circumstances, can the judges in Hong Kong really withstand the pressure in the future in handling their rulings? And in the long runs, all of these criticism, how would that affect the judiciary? Thank you.
Yep, thank you, Chris. On the designation of judges under the national security law, the NSL says the designation is by the chief executive after consulting the Chief Justice. But it is she who designates, and is therefore the chief executive you should be asking about revealing who the judges would be. I don't think it's right for me, proper, to disclose confidential conversations I've had with the chief executive in relation to this topic. But bear in mind what the national security law does say, which is that whoever is a designated judge must come from the existing ranks of the judiciary. And this is something which a point which I've made before, that coming from the existing ranks of the judiciary, all judges go through an appointment process through the Judicial Officer's Recommendation Commission, having to satisfy what is Article 92 of the Basic Law, which says that judges are to be appointed on the basis of their judicial qualities and their professional qualities. There is no requirement, nor is it proper, to be appointing judges on the basis of any political beliefs. It's quite out of the question. So this is the appointment process, and this leads to the body of judges which we have. It is from that body of judges that the chief executive designates judges. In relation to the independence of the judiciary and national security law, this is your second question about how much protection the courts can give to the community, members of the public. You mentioned specifically the right to have people sent to the mainland for trial. The courts don't make the law. The courts apply the law. Applying the law is, of course, harder than you think because it requires a lot of different factors to be taken into account, different legal factors. But the courts don't invent the law. The courts don't say, in this situation, I'm not going to follow the law, I'm going to step in. But when a matter is to be dealt with by the courts under the NSL or indeed any other law, then it has to deal with it in the approach that I've already mentioned. Now, whether that is good enough depends on the views of the public. It is also dependent on what the law says. So it's not an easy question to answer. Oh, does the law give full protection? Because you can't answer that with a yes or no. You can't say, yes, it does. I would say, yes, it does, within the powers which the courts have. The courts don't have unlimited powers. Now, the third question deals with reforms and whether all this talk about reforms applies pressure on judges. A lot of people think it does because people criticize the judges, not in gentle terms, because I think the trend nowadays with some people is to criticize in strong terms, and sometimes even too strong terms. Your question is whether it gives pressure on judges. All I can say this unequivocally, it does not give pressure on any judge. Nobody likes to hear nasty things about them in the press, or they're called names, or worst of all, doxing. But to say that it applies pressure on judges to do what they otherwise should be doing, I think would be wrong. I know of no instance, I know of no judge who will feel the pressure to change his or her approach to the dealing of the case just because of any criticism from whomever it comes, whether from the press, whether from individuals, whether from organizations. The reason for this is judges, I mentioned this, take an oath, and the oath is to follow the basic law, is to decide cases without fear or favor. I would be more worried if judges did not follow their oath, did not do what they are meant to be doing. That would worry me more than all the criticisms, good or bad or abusive, that judges face. So the answer, I could say your question is there pressure on the judges? The answer is no. It's not pleasant. I don't deny that, but to say that it applies pressure on a judge to do something which he or she would not otherwise do, for me, is out of the question. And I've seen no evidence of that.
EFP.
Thank you, Mr. Ma. 3 questions from AFP. The first question concerned, why did you accept to be a designated national security judge after all the controversies around the law? Did you have a chance to say no? Are you proud of the role? Second question, still about national security law. Regarding recent criticism on the judiciary's handling of national security cases on Chinese state-owned media, would you worry that the judiciary will suffer repercussions from authorities in both Hong Kong and Beijing if it cannot get rulings that meet Beijing's expectation? A third question is an overall review. How would you describe your relationship with Beijing and the change of it during your term as the Chief Justice? Thank you.
Strange question asked me whether I'm proud to be a designated judge. I was a designated judge for the hearing last week. If you are designated a judge to deal with a serious legal issue, as we had to last week, you simply deal with it. It's not a matter of taking pride in it. It's not a matter of having any feelings about it. You just get on with doing the job. What motivated the chief executive to designate me, or indeed anybody else, as a judge, quite frankly, is no concern to me. I'm concerned that, only concerned that the judges and the courts are able to do what they are meant to do, and this I've explained in the last question to Chris Lau. Now, pressure from Beijing and also relation of Beijing, these are your second and third questions, and glad you asked me about those, and because this is something which needs an answer too. The short answer to a question which I'm sure a lot of people want to ask and do ask me is, do you, as Chief Justice, does the judiciary get pressure from the Hong Kong government or from Beijing to do certain things? To do certain things, meaning to decide cases in accordance with what they would like to see as a result of cases. Do I get that pressure, and have I got that pressure in the last 10 years? And my answer to you, truthfully, is no. A lot of things are said in the press said by many people. I've already answered the question whether they give pressure on the judiciary, and they do not. Do I have any direct, as it were, because the question is, any direct interference with what I do, or what the courts do, from the government or from the mainland government, from Beijing? The answer is no. Now, as far as that is concerned, that answer is concerned, the follow-up question to that, which I think is a legitimate one to ask, is what shows that what you've just said is right? I mean, are you just simply asking the people in this room to believe you when you say the answer is no? Now, actually, it's not good enough for me simply to say, I hope in my last press conference to you, please believe me and please report in the newspapers or the outlets that that the Chief Justice says there is no pressure, and let's take his word for it because, well, let's say for the sake of argument, but because he's a good guy and you like him and he seems to have done all right. Not good enough as an answer. The way that you can test this is the only way you test anything. And I would urge anybody who's making, who writes about the work of judiciary is to do so and come to views objectively, based on objective facts. If at the end of your examination of objective facts, you come to the view, well, I think the judiciary is not as good as it's made out to be, or it is doing its best to uphold the rule of law, that is fine. I have no problem with any views or views to the contrary. But what I do ask people is to make comments and views known based on objective facts. What do I mean by objective facts to test what you've just said? Take as an example, look at the judgments which we have issued. The judgments reveal the best attempt made by the judiciary to further transparency. Transparency in the judiciary is important. It comes in two forms. One is that you're able to attend almost any court hearing. There is no such thing as a closed hearing, except when you're dealing with sensitive cases, say involving children or things like that. The other form of the transparency is the judgment itself. Now, I know there's been criticism of the judiciary that, oh, your judgments are too long. So, you're a busy person, particularly if you're a busy journalist, and I have time to read through a 50, 100-page judgment and so on. Well, I'm not here to debate whether judgments should be shorter and so on. We can debate that another day. But what it does show is that it shows every step of the way of the reasoning which the court has employed to arrive at a result, whether in a criminal case or in a civil case. In a criminal case, why a person has been found guilty, why a person has had his or her appeal allowed or dismissed, and of course this goes all the way up to the Court of Final Appeal. You are able to look at the reasoning of the court in detail in a way which shows, I hope, transparency. Because if the less reasons you reveal, the more speculation there is from people as to what has motivated a certain result. So when you talk about objective facts, the judgment tells you this. Now, we do our best when it comes to certain important judgment also to provide summaries. We provide press summaries. I think you all know that from the Court of Final Appeal in every judgment, and in lower courts in relation to important cases. And also you've noticed, although nobody's asked me this, about complaints made against judges, we also, for the more important sensitive complaints, upload reasons why a complaint is upheld or not, as the case may be. Now, going on to the third question, because your second question relates to relationship with the mainland and Beijing. Throughout my 10 years as Chief Justice, I have paid particular emphasis on the need to develop a good working relationship with my counterparts in the mainland. The constitutional model of one country, two systems, insofar as it affects the law, shows that the legal systems in Hong Kong and in the mainland are quite different. Therefore, the need to have exchanges is there. I have tried in my 10 years to develop these relationships. In fact, until last year when travel was not possible, the visits to Beijing to meet up with my counterparts, mainly the Supreme People's Court and the judges there, were quite frequent. It would be 2 or 3 times a year. And these, I hope, will continue to develop because there is a need to understand the legal systems of both places. But of course, as far as Hong Kong judges are concerned, the application of laws to cases is wholly dependent on Hong Kong law and specifically the Hong Kong Basic Law. I'm sorry the answer is a bit long, but it is a necessary one to iron out some misunderstandings.
CJ 你好，打 TV 嘅，咁咧都想問頭先，其實頭先都有行家有問過，都想 follow 翻啦。即係 CJ 你有講過你嘅使命其實10年嚟就冇變啦。咁但係呢10年嚟就係好多人頭先就問過，都係法治已死呢個問題。咁我相信 CJ 你唔認同法治已死嘅，咁但係你都好難否認就係公眾對呢個司法制度或者即係呢個司法獨立其實係有失望同埋信心動搖。你覺得點解大家會對呢一個司法制度失望或者信心動搖？係邊個有最大嘅責任咧？同埋即係 CJ 你作為即係首席法官咧，你有冇覺得自己有做得唔好嘅地方？又或者有邊啲地方係其實你自己都覺得係無能為力嘅咧？咁同埋頭先都提過就係話希望市民都會尊重法官、尊重法治。咁你覺得唔尊重法官、唔尊重法治嘅，其實係咪淨係得市民咧？咁第二個問題咧，都想問翻就係都頭先亦都有好多嘅行家都問過咧，即係其實法官有冇受壓啊，或者有冇人施壓啊？咁即係你都覺得你都話係冇嘅。咁不過我哋都有啲即係例子見過，就係記得之前呢個禁蒙面法喺原訟庭嗰個司法覆核咧，去裁定咗禁蒙面法係違憲嘅時候咧，中聯辦同埋港澳辦都即係公開發個聲明，就話咁呢個裁決係公然挑戰人大常委會嘅權威嘅咁。咁呢個我哋即係作為市民去睇就覺得，咦係咪一個施壓咧？或者甚至乎係覺得好似打開口牌去教法官判案喎咁喺呢個情況之下，即係咪仲係做到司法獨立或者即係不受干預咧？即係點樣去說服市民咁嘅情況之下，即係冇人施壓或者係即係法官係唔會受壓嘅咧咁？咁另外最後都想問翻咧，其實曾經有外媒就報道過咧，就話馬官你即係可能對於內地官員覺得佢哋唔理解司法獨立嘅意思咧，你就覺得攰啦。其實有冇呢一個情況咧？你會唔會有啲澄清咧？或者即係馬官喺10年嚟有冇啲時候都做到覺得都真係攰啦？係有啲咩原因咧？咁唔該晒。
今日你聽到我就其中一個期望咧，就係人人咧都係對司法機構有信心，對香港嘅法治係有信心。呢個係我嘅期望。嗱，當然咧係好多人就諗有時點解我哋嘅法庭係咁樣判嘅咧？我完全唔同意。法治係香港係冇法治嘅，同埋咧你好似嗰啲法官咧，你咁樣判咧，一定你係偏幫一方，偏幫政府或者偏幫啲被告人啦咁我就諗呢度咧就係好啦。你咁樣諗法咧，你要問自己，你點解咁樣諗法？係咪因為你唔滿意嗰個效果、嗰個判決？如果係淨係咁嘅咧，就係其實好多人都係咁樣諗，但係唔應該咁樣諗。因為如果你講法治係香港冇法治，你要揾啲理由，你要揾個理據。剛才我講咗，你要揾啲 objective facts， 咁你要睇。你要睇第一，你要睇嗰個法庭出嗰個作出嘅判詞佢有咩理由？你對嗰個 result 唔滿意？你要問點解佢咁樣判？呢度咧個問題好容易答嘅。你睇嗰個判詞嗰個 judgment 嗰度如果係個判詞係有啲少少弱咧，或者係錯嘅咧，咁嗰啲可以上訴㗎。呢個係我哋嘅制度，上訴去上訴法庭，上訴去終審法院嗰度。所以咧，如果你淨係話法治係冇嘅，係死咗嘅，係因為你唔中意嗰啲判決咧，呢個係我覺得係比較難啲接受嘅。咁如果你話係即係嗱 ，Reuters 好似問係寫咗係咪我對啲好似好攰？你剛才你講嗰啲嘢，就好似嗱，呢度我點樣答你咧？就係從來我未試過係政府或者內地啲朋友咧，或者香港朋友咧，內地啲法官、最高人民法院係咪真係有俾壓力我嘅咧？係冇咁樣嘅壓力，即係好似嗰個就諗一定好攰，所以我唔中意講法律嗰啲問題，我寧願講曼聯或者講第二啲嘢嘅。唔係嘅我上去北京見最高人民法院嘅嘅院長同埋其他啲法官，我哋係講係嗰啲 好正經嘅嘢嘅，講法律嘅問題。即係我哋係兩個制度咧，一定係有分別嘅嚇。因為我哋嘅一個係一個普通法嘅制度，佢哋係民事法，所以係好多大嘅 differences 嘅。但係我哋都有得傾嘅。即係如果你話攰嘅意思，好似話啊，佢一定不停俾壓力你，不停話啊，你一定要咁樣判，你唔可以判俾呢邊贏嗰啲嘢嘅，冇咁樣嘅事。呢度嚇，剛才已經話有咩可以證明係冇咁樣嘅事咧？你要睇啲objective facts 㗎啦。好，
明報啊。
CJ 你好，明報嘅，想問翻都係國安法嗰個範圍方面啦，因為你自己退休前夕都擔任咗呢個國安法法官啦。咁想問下，其實即係你頭先就話唔係因為即係自己個人情感問題而去接受呢個職位啦。咁但係其實你接受呢個職位嘅動作係咪即係反映其實你對國安法係有信心嘅咧？覺得國安法其實同香港嘅法律係冇抵觸嘅咧？同埋其實究竟而家國安法立法之後，究竟其實係咪仍然係基本法係凌駕國安法咧？另一條問題就係，即係頭先都有行家提及過，即係除咗禁蒙面法受到中聯辦嘅批評之外，其實最近蘋果日報創辦黎智英佢喺高等法院獲得保釋之後，其實人民日報啦、大公報、文匯報等等報章都係連日嚟發表好多評論文章，就係批評法官李運騰嗰個判決啦，甚至係講到話其實單案已經係觸犯國安法第55條啦，甚至係要求法庭作出一個正確嘅選擇。咁其實呢啲係咪都即係單純嘅批評咧？會唔會其實已經係超出呢個批評範圍，直接同法庭施壓咧？咁仲有一條問題就係，即係你頭先都提及過，其實近年嚟其實你出聲明嘅次數係比較多嘅，咁同埋即係可能香港近年嚟面對法治嘅挑戰都比較多啦。其實覺得律政司會唔會係比法庭更適合去做發聲明或者主動發聲嗰個咧？因為之前都有啲法官喺判詞都有講，其實傳統上負責司法公正嘅首長係律政司司長啦，有責任維護被外界錯誤指控嘅法官，但係呢個傳統就不幸地倒退，現時都唔一定及時履行。咁會唔會都認同嗰位法官喺判詞所講嘅嘢咧？唔該晒。
第一個問題你問我係因為我上個星期係處理咗一個案件啦嚇，咁啊依個係咪等於我係對國安法有信心或者係咩？其實依個係唔係即係唔係一個正確嘅問題？因為我對一個法律有信心或者冇信心咧係冇關嘅，係 relevant。如果要做啲嘢咧就要做㗎啦。我做咗咧就唔係等於話我對嗰個嗰個法律係滿意或者不滿嘅嚇，直情係即係用英文講咧 ，just have to get on with it。如果你要處理啲案件嘅，同埋咧，我又唔敢講太多。即係你琴日你剛才嚟講咗嗰個上個星期嗰件案咧，黎智英咧，咁就係2月1號終審法庭就會審㗎啦。依個就係。所以唔係好適宜係講太多。第三個問題咧，剛才我哋講係對香港嘅法治咧，有好多人、好多機構咧都有責任㗎。我係當然有責任，司法機構都有責任㗎。但係咧，你話你講邊個咧？律政司司長或者其他人？佢哋有冇責任？一定有責任嘅嚇。我咧，如果係需要講啲嘢，要出一個 statement，咁我就一定會㗎啦嚇。呢個唔係話係批評人，我唔想批評人，因為我覺得呢個都係冇關嘅，都係 irrelevant 嘅。所以咧，如果需要出，所以係市民可以了解我哋嘅制度，可以了解香港嘅法律，咁就呢個就需要做啦。舊年係出咗，即係過去1年係出咗都唔少㗎啦。
Christy Lustat with CNN. Chief Justice Ma, first of all, congratulations on your retirement. A personal question, if I may. How has it felt to continually uphold the integrity of the courts in Hong Kong, to continually defend the independence of the judiciary in Hong Kong, especially these last few years. And what's your advice for the next Chief Justice?
Well, thank you for those nice words. How's it felt? Well, of course, it has been a privilege, and you'll hear me say this tomorrow, that it's been the greatest privilege of my professional life to have been Chief Justice. Defending the independence of the judiciary and the rule of law is necessary. And it becomes more necessary when there may be misunderstandings in the community about what it means. I've said that it's good and healthy for people to discuss the law and the work of the courts, even to criticize it, because at least people are showing an interest in it. Where it requires something to be said on my part is when I perceive there are fundamental misunderstandings. And the most fundamental misunderstanding of last year, which I needed to address, are the views of certain people. It's not a matter of fault or anything like that. When people think that judges, in fact, are biased when they arrive at different verdicts, usually in criminal cases, in saying that, this judge must be politically be biased one way or the other because of the result which has happened. Either there's been a conviction, or there's been an acquittal, or when the sentences have not been to people's liking. So there's a ready assumption that the judge is biased politically. That's when, in particular, I needed to say something, to say that this is not so. And quite often, the very people who praise you one day are the very people who condemned the judiciary the next. Now, it is really to deal with these misunderstandings that I've had to say something, and that doesn't pose a challenge or give me any pressure. It's just something necessary to be done, and you hope by offering an explanation, which again is part of an attempt to be as transparent and, let's face it, to be as honest as you can with the public. That is why I do it. And I've used this word honest, I think, before in any of my press conferences, but I think I can say this in my last one, is that it is important for the Chief Justice, and certainly was important for me, to be as honest with the public as I possibly could. And in terms of not up to me to give advice to my successor, but if he were to ask for my advice, I would simply say, stick to basic principles, stick to your principles, because these are the principles that will help you in your office and which will, I believe, ultimately help Hong Kong.
我哋最後兩條問題啊嚇，星島。
你好，我係星島日報嘅。你啱啱講過咧，你退休咗之後唔會做終審法院嘅非常任法官啦。咁其實喺國安法生效之後咧，你覺得終審法院有冇需要喺常任法官或者非常任法官咧增加一啲本地嘅法官咧？咁另外咧就係近排咧都有好多裁判官係處理示威案件嘅時候被投訴啦。咁至今公佈咗嘅案件入邊咧，總裁判官咧話審視咗之後都覺得啲裁判官係冇錯嘅，而你都有同意總裁判官嘅決定啦，咁就俾人話係官官相衛喎，咁你覺得有咩睇法咧？
其實個國安法咧都係冇規定係話係一定要係上任或者非上任嘅法官，亦都冇話係一定要本地法官或者係海外嘅法官，所以呢度咧就係呢個係個國安法都係咁樣規定嘅。 咁就其他嗰啲問題，如果你問，你要問特首辦嗰度，或者問特首點解你揀依個或者係嗰個。第二個問題係咩 ？sorry， 我第二個問，係裁判官俾人投訴咧，喺依度咧就係都係人哋就唔滿意佢嘅佢哋嘅決定嚇，即係佢哋或者係話有罪或者冇罪，好多人都批評嘅。特別咧，如果有呢啲政治嘅原因嗰啲案件嘅咧，一定有嗰啲人係即係好有啲 strong feelings 嘅。佢話一定點解呢個人係放咗佢啊？或者點解呢個人你要係有罪啊？應該冇罪嘅喎。呢啲係咧好多時咧係呢啲人批評我哋嘅司法機構，係因為佢哋係有啲即係嗰啲政治嘅方面，即係政治嘅因素，佢哋係政治方面嚟批評嘅。呢度咧，我就想強調咧，對我哋嚟講，對我哋法官嚟講咧，呢政治嘅因素、政治嘅方面咧，係完全係 irrelevant 嘅。我哋淨係睇法律，同埋咧有罪冇罪咧，你要睇嗰個證據，即係睇個 evidence 嗰度。
Last question. Washington Post.
Washington Post reporter, Chief Justice Ma, you've said that those who are not satisfied with judgments can appeal, but we've seen a number of cases appealed by the a number of cases that were appealed by the DOJ on cases that were related to the protests last year, and verdicts were changed to increased sentences. Does this concern you? Do you think it's an indication of the DOJ inserting itself in an abnormal way into judicial proceedings? And what does that mean for judicial independence? Second question, you mentioned that the Chief Justice mission is to preserve the rule of law. Do you have any concerns that the next Chief Justice will not be as committed to the rule of law? Thank you.
It's part of our system of law that we have system of appeals. And in Hong Kong, there's a double-tier appeal to the Court of Appeal, and then if the circumstances are right, then to the Court of Final Appeal. The reversal of a decision of a lower court doesn't concern me. Of course, it doesn't concern me because that's part of our system. You may be surprised that there are a number of cases I've heard which have been overturned by the Court of Appeal when I was in the Court of First Instance, and a number of cases which I've dealt with in the Court of Appeal which were overturned by the Court of Final Appeal. I don't think it was meant by that there was some cause for alarm, except that as a matter of law, the higher court saw that there had been an error of law or something else. It doesn't bother me. It should not bother anyone to see that an appeal has been allowed. Now, of course, I'm speaking generally. If there is cause for concern, because again, the first point of reference is to look at the judgment itself. And looking at the judgment, we'll see if the lower court's ruling or determination has been reversed. Just what the reasons for that were. I mean, the worst is, of course, I was just taking an example. The Court of Appeal allows an appeal on the basis that the judge in the lower court has been biased or something like that. I mean, that causes me concern. What causes more concern, which, by the way, this is hypothetical, this example which I'm giving you, but it underlines the point. If the higher court says, we must reverse this decision because the judge below had taken a bribe. Now, if that were the reason, of course that would bother me. But if it is a matter of law, then this is part really of the system. Now, in relation to your second question as to whether I have confidence in my successor, the answer is I have full confidence in Mr. Justice Cheung that he will uphold those principles which I've been talking about. I think I said in January, about a year ago, in the press conference following the opening of the legal year, I think I said this, but I'll say this again. I retire when at 65. That's the retirement age which I had when I joined the judiciary. Retirement age has now gone up to 70. I could have then extended to 70, and then perhaps even extensions beyond that. I would not have left this office at all if I thought that there was nobody suitable who would take over from me. Somebody suitable and good will be taking over, probably better than I. And that, I'm confident about the future. Of course, Justice Cheung will face many challenges, as indeed I had to face challenges, and in the way that my predecessor, Andrew Lee, had to face challenges. But I believe he will be able to deal with it in his own way. But of course, whether he succeeds, whether I have succeeded, is a matter for the public, it's a matter for the community, and also a matter for all of you. So I thank you again for your support over the years. It's meant a lot to the judiciary. As I say, even when you think you've been criticizing or have been criticizing the judiciary, those have been constructive criticisms, and it's deeply appreciated on my part, and I thank you all for it.
多謝大家，咁今日記者會結束啦。咁頭先咧，其實有記者提過咧，想同 CJ 合照嘅，咁請嗰啲記者咧留一留步。咁我哋要稍時咧準備一下嘅，咁你哋留步嗰啲可以，即係想影相嗰啲可以喺側邊等一等先。咁我哋準備一下。
好，我飲杯水先啦。